All right, Supreme Court of Guam is now in session. The Honorable Chief Justice Robert J. Torres presiding.
Today, you may be seated. Will the clerk please call the case?
This is Supreme Court case number CRA22-004, People of Guam Plaintiff Appellee v. Eligio Adriatico, Defendant Appellant. Appearing for the Defendant Appellant is Attorney Stephen P. Hattori. Appearing for Plaintiff Appellee is Attorney Daniel Morris. The panel consists of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, and Associate Justice Catherine A. Merriman. Attorney Hattori reserves 10 minutes.
Mr. Hattori, you may proceed. Welcome back, counsels.
Good morning. The case before the court is very important for two different reasons. One, it addresses the issue of whether the highest court of a territory, specifically Guam, may interpret its own Bill of Rights in a manner that differs from the interpretation provided by the U.S. Supreme Court. And the second issue that is very important is whether Guam, consistent with Guam laws, will treat youthful offenders differently than full-blown adults. I'll start with the first inquiry.
But before we do that, can we just address the compassionate release issue? As the court below determined that he was not eligible for compassionate release, and you did not file a reply brief that addressed that issue. I know in the opening brief you argued that the court should have erred by not treating the pro se motion for compassionate release as a writ of habeas corpus, but we had already determined that we had jurisdiction over the denial of the release denial of motion for compassionate release. So what is the position? What is you think that the government's argued it's moot?
Yeah, well, Your Honor, basically, as far as the compassionate release argument, if I were appointed to represent initially, I probably would have just filed an Anders brief on that issue. But I know the court asked us to brief, and I thought it would be more properly handled as a writ of habeas corpus. I think that ultimately the court made specific findings that factual findings that would not support a compassionate release under the standards.
Yeah, but the habeas corpus remedy is normally regarding convictions. I don't recall us seeing or addressing a case of habeas that has to do with illegal sentence or that has to do with sentencing.
Yes, and so because we're raising constitutional claim of cruel and unusual punishment, we believe that this would properly fall under a writ of habeas corpus, that he's being improperly confined due to unconstitutional or inorganic sentence.
All right, so are you abandoning then on appeal the compassionate release argument?
Yes, we did not reply, and I mean we don't believe that there was. I mean, just factually, that the court abused its discretion in denying that part of the relief. We believe that he actually should have treated it as a writ of habeas corpus.
You don't feel you should consult with your client because your client raised it in his moving papers?
Well, Your Honor, I did discuss that issue, and we did decide to proceed with the habeas argument as our primary argument.
Assuming that's a proper remedy.
Yes, assuming that's a proper remedy. And so
now, the trial court didn't address the cruel and unusual punishment claim that was raised also, on the youthful offender status at all.
And so that's why the relief we're seeking is for a remand and to have an attorney appointed to represent him, to defend him, raise this constitutional or organic act claim, and an attorney would be able to make a proper record whether it's through the introduction of evidence, calling of expert witnesses to support.
How would that work? Right now, in reference to the applicability of the protection of no life without parole for certain crimes committed, which are pertinent to Mr. Adriatico's sentences here, sentences here. The Guam Supreme Court has not adopted this protection, extended it to what has been defined as emerging adults, those aged 18, 19, and 20. There are a lot of issues which I'm sure we'll touch on this morning before we can get there. But would a remand to the trial court be more helpful to the defendant and the government in letting the trial court review the applicability of this evolving brain science to juvenile offenders? Or is this something that the Supreme Court should weigh in and then have the trial court try to apply it to the facts, circumstances of this case?
Yes, well, actually, we believe that a remand is necessary so that any additional evidence, especially experts, can be provided to the trial court level. We presume whichever way the trial court rules would then get appealed, and then the Supreme Court would have the entire record that's been established.
So I was trying to think that through if I was in your position. And in the first instance, you must convince the trial court that the protection extended for no life without parole for certain crimes applies to emerging adults. Because right now, the U.S. Supreme Court, all the federal circuits, is that it only applies to those under 18. I mean, that's the state of the law in the federal courts. In the state courts, you have certain jurisdictions that have extended it to what's been defined as emerging adults, 18, 19, 20, maybe even 21. So that's, I think, the first step. And then I would, if you convince the trial court that this protection should be extended, what type of evidence do you present? Now, I mean, this crime occurred over 40 years ago. The crimes occurred over 40 years ago. What evidence is presented to try to come within the umbrella of this protection for your individual client?
So the way it would apply my client's specific case would be that he would have to convince a parole board following the factors that the parole board, if the court were to, if I was able to convince the trial court that the sentences were illegal because they were cruel and unusual due to his youthfulness, then it would be converted to a life with the possibility of parole. And then we would go before the parole board and see if he could be released under their guidelines. And in this specific case, he's also not a U.S. citizen, so it's very likely he would eventually get deported as a part of his, if he were ever released on parole. And so, at the very least, it would give him an opportunity, and it would give other similarly situated youthful offenders who an opportunity for potential release depending upon their behavior and any rehabilitation that they can establish. But that would definitely go before the parole board.
But if we were going to remand the case, as you argue, to the Superior Court for a federal constitutional analysis of whether life prison without parole constituted cruel and unusual punishment, and the court believes that the framework that was established in Guerrero still applies, isn't that going to just be futile? I mean, don't we have to address that issue first as to whether or not that analysis, the Ninth Circuit decision in Guerrero, was either binding or not binding?
Well, Yeah, absolutely. And that's why, the court, this is an opportunity for the court to look at Guam v. Guerrero and possibly distinguish it in light of the Limtiaco decision. And because we believe that the application of the cruel and unusual punishment clause of the Organic Act is one of purely local concern, right? Anytime you sentence a defendant on Guam, it really is one just of purely local concern.
Doesn't our law address that in the Youthful Offender Act?
We
We've
do.
done that already.
In 1964, Guam did enact a Youthful Offender Act recognizing that, maybe possibly this is in 1964, recognizing that youthful behavior should be treated differently than adult behavior. However, there was.
Except for murder though, right?
It did carve out an exception for life sentences. However, that Youth Correction Act was never implemented, so there is no facility separating our youthful offenders from the regular adult population.
So do I understand your argument that the court should first address Guerrero, People versus Guerrero, the Ninth Circuit case, whether or not we wish to continue to follow it or depart from it? And assuming that we depart from it, that a remand would better serve the clarification of the issues, whether this principle should be applied as a facial challenge, and that is all sentences that applies all sentences. The protection is applied to the emerging adults. There's also other jurisdictions that have taken the approach, like Illinois. It's an as applied challenge, and it depends on the crime, the defendant's circumstances. And so are these better suited for the trial court to kind of look at, and for the government to have the opportunity to weigh in as to which approach should the Guam jurisdiction adopt? Or is this something that the Guam Supreme Court should just move on and make that decision, and then remand it to the trial court as to how to apply it to the circumstances of your client?
And I think, the as applied approach would be easier in the kind of cases where if we're going forward, it would be as applied. But because of the age of this case, it would be difficult, to bring up a factual basis indicating that at the time of the offense, he was, obviously under the influence of the older co-defendants, and that he lacked the ability to control himself and lacked impulse control, as well as the cognitive abilities of an adult when he was 19 and 20 when these incidents occurred. But as far going forward, we anticipate that if the court were to make a bright line ruling that youthful offenders, it's really tough because.
But before you continue on, it just reminds me that if we're going to weigh in here, as I understand the research, the Washington State Supreme Court is the only jurisdiction that has extended it by case law, and the government, at least in their briefs at the time that it was filed, it was Assistant AG Waldischuk who did the brief, maintained that all other jurisdictions, and I think there were 6, 7 more that have extended this protection, has done that by legislation. Is this better suited that as a policy decision? The government argues that this protection should be extended by statute and not case law, which none of the federal courts, no circuit court, of course, the U.S. Supreme Court has pronounced its position. And assuming that we can deviate from that and departing from Guerrero, is this something that we should address through case law, or is this because of the multitude of issues better suited for the legislature to decide in the first instance?
Yes, I mean, I believe those are two avenues that really public policy can go down. But I think in interpreting the application of our Organic Act, the court has a broader authority than, Guam versus Guerrero suggests. And, I think Massachusetts actually recently also extended the age to 20 or 1920, and they reversed a sentence of life without parole for 19, 20-year-olds who were convicted of homicide. And that's the Commonwealth versus Matis case. I think we submitted as a supplemental supporting authority. And so, but really, it's the issue is Guam versus Guerrero, right? And the restriction it provides. And I know that the court previously in the Moses case also suggested that you can't deviate from the Bill of Rights interpretations unless the language is different.
Well, let's assume, for argument's sake, that we accept that we could provide greater protection under the Eighth Amendment and therefore not follow the federal courts, all the federal courts which have not extended the youthful offender status to those that are over the age of 18. Don't we still have to examine and look at whether the life without parole violates the evolving standards of decency for a society? And hasn't the legislature already made a determination, at least that life without sentence is appropriate for youthful offenders? So if we're going, I mean, how do we get around that hurdle?
And this is why the Constitution exists. Sometimes statutes are old, and because our standards of decency and our understanding of the mind have evolved faster than the legislature can act. I think that's what the Washington
What other indicia do we have from Guam, objective indicia that we can look at to suggest that these evolving standards of decency, require us to determine that this imposing a sentence of life without parole would constitute cruel and unusual punishment?
So, I mean, I think there's, Guam law over the time has changed, right? I mean, when in 64, when they passed the Youth Correctional Act, they identified youth offenders as 18 to 25, although it has never been implemented. There have been numerous laws raising the drinking age to 21. In that Munch case we cited from Washington, they actually went into the history of the age of majority, and apparently it was changed in 1942 from 21 to 18 to allow 18-year-olds to get drafted into the war, World War II. And so that 18 really is just a chronological fact, but there's so much more, right? The logic behind treating an 18-year-old 17-year-old differently than an 18-year-old applies, whether you're 18 or 19 or 19, 20. And that's what we believe the scientific evidence would show. There's other examples within Guam law, like the drinking age, smoking cigarettes, I think even marijuana.
So you think that remand for further post-conviction proceedings would give him the opportunity to go through this exercise of why this evolving science on juvenile maturity, brain development, Guam laws and changes, to be able to set forth that, and it's better suited for the trial court to do that?
Well, I mean, I believe the court can issue, a bright line, or actually as applied in this case, and then in the future, other youthful offenders might be able to make the claim if they fall within that age range.
What would be the bright line? You're asking us to just choose an age?
Well, so, and that's the problem without a evidentiary. I mean, Guam's already recognized youthful offenders between the ages of 18 and 25, and really, they were really ahead of the time, because it's jurisdictions just now are passing youthful offender statutes, and ours has been on the books in 64.
So did I understand then
Like-
that if we were to strike down the protection or extend it to youthful offenders as defined in the Guam statute, and it now also applies to murder convictions, that the age group, the emerging adults definition would be 18 to 25. I've not read any, and I've done very limited reading on this, but I don't think any other statute or any other state jurisdiction has extended it all the way to age 25. Would we be in an anomaly? And can we even deviate if if the legislature has said youthful offender is 18 to 25, and we strike down that the provision that it doesn't apply to murder convictions, and we say that it constitutes cruel and unusual punishment? Are we constrained by the statute? And we can't say it's 18, 19, 20, but Guam law says it's 18 to 25. So that's what we're constrained with. Is it with that
And
how this turns out?
well, and so that's the problem with the so the logic that the Supreme Court has used in prohibiting, life without parole for 18 and under, that same the same analysis would apply to someone who's 19 and who's 20, arguably. And so it's kind of hard to say how high we should go.
Well, the Washington State Supreme Court, I mean, they drew the line, 18, 19, 20.
Yeah.
It applies. Illinois, the Illinois State Supreme Court has not weighed in, but allowed the trial courts and the intermediate courts to apply the provision as applied in reference to that the protection is extended to emerging adults. I don't know what the Illinois absent a statute, and absent a state Supreme Court ruling, what is the age group? But if I understand the contention here is Guam has adopted the Guam Youth Offender Statute. Their youth offenders defined as 18 to 25. It carves out that it doesn't apply to murder convictions, but if we strike it down as cruel and unusual for youthful offenders, then our hands may be tied as to, no, it only applies to 18, 19, 20, as what the literature is suggesting.
Yes, and I don't think it's necessary to reach that point, and maybe it's something that like an that's why we would need the evidentiary hearing to establish what that age would be, whether it's even applicable to Mr. Adriatico, who was 19 or 20 at the time. And so and that's why we're asking for a remand. We're not going so far as to say that youth who are older than 20, within that 18 to 25 range should all be eligible for life with the possibility of parole, because we just don't, we need to present the evidence to support that position.
Well, your client was 21 when he committed the offenses at DLC. So if he's going to benefit from extending the protection, I think the argument would have to be it's 18, 19, 20, 21.
Yes, and that's what we would argue, that 21 would be a cutoff age, but it would also depend on the kind of evidence that we're able to present at a hearing. But the justice is correct. There isn't any increasing it to 25 is not something any states or districts of circuits have done, and I don't know if the literature would necessarily support that. And I know that the various cases have indicated that the age of maturity actually varies among even young adults. So some young adults who are aged 18 may really be more adult than some juveniles young adults who are 20 or 21. And so hopefully those are some of the things that the trial court can look at.
Can you address Guerrero specifically and why you believe we should depart from the reasoning of Guerrero?
So Guam versus Guerrero, I mean, I know that they indicated that the Guam Supreme Court cannot afford greater protection, right, than the similar US constitutional provisions, but the Ninth Circuit kind of jumped to that conclusion without considering the legislative intent or the history behind the Organic Act and the Mink Amendment of 1968. And so we looked at the Virgin Island Supreme Court, the highest court of the Virgin Islands, actually did a thorough legislative congressional intent analysis that was lacking in Guerrero. And I mean, if anything, perhaps that particular issue can, we can be ordered to brief that. And I think that the history, it was all lumped together in the same public law. Was that 96? 90? That also called the Mink Amendment, and which
86, yeah.
Happened to actually became law that the same day I was born. But in any event, if we were given time to brief that issue on the congressional intent, and went through the analysis that Balboni followed, I'm fairly certain, although I really apologize for not providing that in any of my briefs, certain that Congress intended our Supreme Court to have the same powers as the Supreme Court of the highest court of the Virgin Islands. And so that analysis was lacking in Guam versus Guerrero.
Well, in the Moses case, we seem to suggest that the Guerrero ruling made the argument that we could offer protection under the Organic Act broader than the U.S. Constitution, even if there were very similar possibilities. And it doesn't foreclose all the possibility of using the Organic Act in this manner. And we could have it be more protective if the provisions were, substantively different than the federal constitution. And so it seemed like the Guerrero framework or ruling, narrows, or at least in the Moses court, narrowed the availability of that remedy only if the language was substantively different. The language here is not substantively different, is it?
No, it's not substantively different. If you look at just that individual clause, but the Bill of Rights as a whole, and as pointed out in a recent District Court of Guam decision, the law firm of Mike Phillips and Bordalio versus Territory Guam, or it went through showing all the differences between our Bill of Rights under the Organic Act and the U.S. Bill of Rights, and so they're clearly they're not identical, and I think that the Moses limitation kind of unfairly impairs this court's ability in it, and I'm not sure that it's consistent with what Congress had intended for the highest court of a territory.
So we should expand upon Moses then.
Yes, and I think that that suggestion is made by the Limtiaco case, in which the U.S. Supreme Court indicated that if a matter is of purely local concern, then they will defer to the ruling of the Supreme Court of Guam. And so,
although in that case they said it wasn't a matter of purely local concern and had some federal implications, and therefore, that exception didn't apply, right?
That's correct. It involved
and even though it was an Organic Act statute or Organic Act provision.
Yeah, that's correct. So the Supreme Court indicated that even although it's an Organic Act provision of federal law, that it is all serves as Guam's constitution, but because that issue, the tax evaluation in it, could lead to insolvency that may affect the United States as a whole, that it was not a matter of purely local concern. Whereas the issue here, we believe, is one of purely local concern because any ruling would not affect any other state or territory.
So, Mr. Ottori, you seem to be well versed and quite lucid in your presentation of the analysis of People v. Guerrero and the considerations that should be taken. Do you still think that it would be helpful for supplemental briefing on this issue, or is there sufficient research on the record for this court to address the issue?
Yes, I mean, I have to apologize. I really should have, gone deeper and provided that congressional intent at this time, and we would request additional time to brief that specific issue about the legislative intent and whether or not Congress had intended to treat a territorial court the same as a state court.
Yeah, that part is lacking in the briefing.
And the Baboni decision really turned on that, and that ruling was the U.S. Supreme Court denied cert when they tried to appeal that issue to the U.S. Supreme Court. So the Supreme Court didn't even want to entertain the appeal on that issue. And so we believe that because of Baboni, the way the Supreme Court has treated it by denying cert, as well as by that Lim Tiaco decision where they acknowledge that, the highest court of the territory does deserve deference in issues of purely local concern, that, an additional briefing on that issue could possibly lead to the same result as the Virgin Islands Supreme Court in Baboni.
All right, your time has expired, and actually you have no time left for rebuttal. I'll give you 2 minutes on rebuttal, though. Mr. Morris.
Mr. Chief Justice, may it please the court. If I may, I'd like to start by discussing why the court should deny the writ for habeas corpus. And I think there are two reasons here. The first being that under the Ignacio Clark factors,
There's no habeas corpus petition before us, is there? I mean, this is a motion after judgment that was filed as to what, how is this currently before us? I didn't understand it that it is a habeas corpus petition.
Well, I apologize. I understand it to be a pro se attempt titled a motion for compassionate release that the court had determined should have properly been considered a writ for a petition for writ of habeas corpus. And under those circumstances, I would urge the court to deny. I'm sorry for the.
Yeah, we had previously determined when there was a motion to dismiss for lack of jurisdiction, and I know it was before your time, that they could appeal from the denial of the motion for compassionate release, and included in that was that complaint that the imposition of the life sentence without parole was cruel and unusual punishment. The trial court in its order did not address the life without parole as cruel and unusual punishment, but we had in our jurisdictional order said we had jurisdiction over it as an appeal after judgment that affects the substantial rights of the defendant.
Thank you for that clarification. And again, I apologize for not being better.
It's tough when you pick up a case midstream, but
You did really well yesterday, and I'm sure you're going to do quite well today.
Thank you. Nonetheless, I think the overarching first principle is there has been unreasonable delay in asserting this constitutional violation. The Supreme Court, the Supreme Court precedents that that Mr. Adriatico is ultimately relying on were decided in 2010, 2011. As we noted in our brief, some of the psychological evidence that he to which he wants to draw the court's attention was also issued in 2011. 10 years further on, the delay does suggest a lack of diligence on its own part, and it has practical difficulties for the government. As the record reflects, when the Superior Court sought to get key documents about the original sentencing of Mr. Adriatico, those documents simply weren't available. Now, I'm still new to the island. I understand that storms happen here frequently, so it could well have been that the 10 years wouldn't have made a difference. But it's also possible that had this been brought 10 years earlier, we would have access to those materials. At the very least, we'd have access to more of the people who were involved in the case originally. As Justice Carbolito suggested, it were this remanded, and the people oppose a remand, but there would be part of the challenge would be defining the scope. And to the extent that scope included the specific circumstances of Mr. Adriatico's sentencing, the people have been further disadvantaged by that delay in 10 years. So I think that's the first reason the relief sought here should not be granted.
But wouldn't that be all the more reason why, assuming we get over People v. Guerrero and we reach the issue of whether or not the Bill of Rights 14, whatever it is, 21BH, the cruel and unusual punishment provision in the Organic Act, can be interpreted to create greater rights than what is provided in the U.S. Constitution. And when a remand as to which approach is preferable in our jurisdiction, do we follow the Washington State Supreme Court facial challenges of anyone over 17 years of age? Well, not anyone, but the age group, the emerging adults, as it's defined in some literature, 18, 19, 20, that protection is extended to them, no life without parole sentences in reference to various serious crimes committed that's provided for in the statute? Or do we follow the Illinois model in which it is an as applied challenge? And it depends on the facts of the case, the actual statute that's violated, and therefore, if should this go back, and the difficulties of how this is going to be applied, if we were to just announce from the bench here or an opinion that it's the facial challenge, and it's a problem of the trial court how that's going to be applied. Would we be better served in reference to not just announcing what is the preferred, assuming that we do, but consider the realities of how it is actually implemented in the trial court when you're looking at sentences, 30, 40 years ago, number one. And number two, do we know how this is going to extend in terms of other defendants? Are there other defendants similarly? Because I would assume that if we do, it's a constitutional challenge, it would be applied retroactively. Are there other defendants in a similar circumstance that needs the consequence of this decision is, I think, is what I'm getting at. So wouldn't we be better served as a community that this is first vetted out in the trial court in reference to, number one, which approach, and number two, how it is going to be practically implemented. And so we can see what are the myriad of issues that potentially can come out of adopting such an approach. And what is the interplay with the Guam Youth Offender Statute that we've adopted in the 60s?
If the court were inclined to hold that the current jurisprudence, current cases allow it to reach a constitutional issue of whether or not these emerging adults are entitled to the type of special protections we're discussing. Remand would, of course, I agree with I agree with the people agree with the appellant that starting with the Superior Court presentation to develop a record on the issues of those age range, and again, without the presumption that a 19 or a 20-year-old, there is some material difference. The burden would remain on the appellant to evoke that and to try to put forward some constitutional framework, some constitutionally required and practically workable framework. I would note, and this occurred to me actually this morning, it may be necessary to do a slight clarification of the people's brief. Guerrero, I think the specific holding of Guerrero is not necessarily that this court is bound by sort of an amorphous federal law in its decisions, but the holding on 2017 going into 1218 appears narrower, and that's that a territorial court lacks the authority to interpret a federal statute or federal constitutional provision contrary to the interpretation the U.S. Supreme Court has given it. And I don't recall right now, but I do not believe that the U.S. Supreme Court has affirmatively stated that emerging adults are not entitled to the same protections as minors. So,
my understanding is the U.S. Supreme Court drew a line, and it's under 18, in which the protection of no life without parole sentences can apply to juveniles under 18 years of age because of the emerging brain science that they are the various rationales that are put forth in the literature of the difference between a juvenile and an adult mind. And as you've read the cases, they just have to draw a line because that's one of the practical matters that needed to be done, and there just needed this line to be drawn, and other jurisdictions that have done it by statute. I would assume, I have not read those statutes, but your colleague who wrote in her brief and cited a law review articles that every other jurisdiction that has done this, with the exception of Washington, I don't know if that's still true today, has adopted this protection by legislation.
And if I may, I'd respond in two ways there. The first is that there would seem to be no prohibition on the Guam legislature addressing this matter, and that would certainly be the most straightforward and perhaps appropriate. You know, we're discussing developing a record in the Superior Court, and the legislature in some ways is even better positioned to develop that record and to make a considered decision of what's most appropriate in this community. But if the court reads again the Supreme Court precedent as having denied these protections for youthful emerging adults over the age of 18, then I think the question really does turn to whether Juan Guerrero, and regrettably, I believe it's not just Juan v. Guerrero that may cause some challenges. I note that in that decision, there was a reference to a prior Supreme Court decision, Weems v. United States, from 1910, and it actually dealt with cruel and unusual punishment in the then U.S. territory of the Philippines, and stated that that the provision was taken from the Constitution of the United States and must have the same.
But all those cases and in the litany that was cited in Guerrero talked about, I mean, those cases applied the federal Constitution as a floor, not as a ceiling. So you had to provide those minimum protections and I think including that case in the Philippines. What we have is a scenario where can the Organic Act provide greater protection than is provided for in the federal constitution, not less protection. And you know, I know you cited that section that talked about a sovereign state interpreting a federal statute in a way that's contrary to the interpretation given to it by the US Supreme Court. But is that really what we would be doing here? I mean, I don't think anyone disagrees that we can interpret the Constitution of the United States in a manner different than interpreted by the US Supreme Court. But what we are doing here is interpreting a federal statute, clearly the Organic Act, but it's in a way that might be contrary to an interpretation given to the analogous constitutional provision by the US Supreme Court. And the, you know, the Virgin Islands and their Supreme Court has gone through, as has been pointed out, and addressed that issue, and has gone through a significant historical analysis of the passage of their Organic Act and their Bill of Rights, as well as cases from the US Supreme Court as well, and including the Adriatico case that was cited, that seems to support deference to the appellate courts of the territory's interpretation of the Organic Act, and not necessarily barring them from providing greater protections than are offered by the federal interpretation of their constitution.
And I think, counsel, that if you really look into this issue more and understand and realize that, you know, the Organic Act, as mentioned in case law, and its functions as the constitutional-like document for this territory. The original provisions that extended the Bill of Rights. In addition, subsequent, there were the Mink amendments that extended further provisions of the U.S. Constitution, 1421 BU, to the territory. There must be some significance rather than just repeating the provisions from A to U, whatever the letter is before U, that Congress had intended. And when you look at in 2004, when the U.S. Congress has granted the Supreme Court of Guam the status of being the highest court, took away the continued appeal rights to the Ninth Circuit, and now treated the Guam Supreme Court as similar to any state Supreme Court, and that any further appeal is by writ of cert to the U.S. Supreme Court. I think that there are significant provisions that can support the interpretation that the provisions in the Bill of Rights can be interpreted. I don't know if it's differently than the provisions, comparable provisions in the U.S. Constitution, but can broaden the protection, as CJ, Chief Justice, has said. The U.S. Supreme Court has set the floor in which we cannot go below, but there's ample authority that provisions, comparable provisions, may be able to be interpreted that provide for greater protection, as in the Balbonia case and out of the Virgin Islands.
I don't mean to presume, because I know I'm literally new to the island. I don't know that there are many people on the island who, and there are several off, who would agree that the fundamental basis of railroad is wrongly decided. At least two members of the current Supreme Court have cited that the insular cases from which Guerrero draws its authority were wrongly decided when decided. And for that reason alone, Guerrero is wrongly decided. The challenge is, I think that Guerrero does expressly hold that it does expressly reject the ceiling and floor theory. The Virgin Islands court, and I recognize, and again, as Mr. Hattori has done, I would do as well for the people. I don't know the circumstances why the supplemental brief wasn't ultimately filed, and why it didn't include a discussion of the legislative history, which is, as I read Balboni, is the missing piece. We would need some element of legislative history if the court were to base the rationale reasoning as the same as in Balboni, to differentiate that this wasn't just intended as an enactment of the federal constitution, but was intended to be drawing from other states. But that may well be possible. I think there is reason. I know a couple of courts have quoted the Adriatico decision, suggesting that the Supreme Court may be indicating a preference for some level of local deference to territorial highest courts such as this. I think the language can also be read as skeptical of supplying a level of deference. The language, the quote at 491 is, it may be true that we accord deference, and the court goes no further, and the court concludes by saying that this is a federal statute which we're bound to construe according to its terms. And of course, this is also a court that at the moment is having challenges with Chevron deference. So for a lot of reasons, I'm not sure that the Adriatico is, and I apologize if I'm mispronouncing that, may not be an indication of.
Well, I think the distinction in Adriatico was, they said if it was a matter of purely local concern, it wouldn't be a problem. But there was an issue about whether the federal fisc might be affected by the local courts, and therefore, or by the local action, and therefore it was not one of purely local concern, but was one of federal and local concern, and that was the distinction. But I think, you know, if you look at the logic, you look at the history, you look at the precedent of the cases that talk about or Organic Act Bill of Rights or Organic Act issues and its interpretation by the courts, rather than say that it's a federal constitutional statute that automatically has to be coextensive with the Constitution, I think that it allows the courts to be able to look at not providing less protection, but more protection than is necessarily offered. And obviously, you know, this debate has been ongoing for a number of years, and you had 3 jurists and then a unanimous decision in Guerrero make a decision that believed that it could not be interpreted that way, but it clearly has been in before them and even after them, and it appears that, you know, their decision might not at least be rooted in the history or the precedent that was there, and I think some of their conclusions, quite frankly, and if you look at a closer read, might have even saying that we have to interpret our Organic Act lockstep with the federal Constitution might have been misplaced.
I think, and I know I'm closing in on the end of my time. I wonder if I might make.
Do you think you would benefit from additional briefing, supplemental briefing on this issue?
I do. I do not in any way mean to overstep, but given the what should be a heightened level of local interest in this area, it might be worth. It might be that the court would indicate a welcome to amicus briefing on the issue as well. I know it's unusual to have that take place after the oral argument, but under the circumstances here, I don't think that the people would object to that, and if the court deems it appropriate, further argument, of course. I would note we are talking, about a couple of different things. Regardless of the constitutional issue, though, that does not necessarily, the resolution of that constitutional issue does not necessarily mean that Mr. Adriatico it would be entitled to release, or that this court should adopt the Washington standard, even if it just determined that it was free to remand this matter to the Superior Court for building that record and making that determination. I think there would still need to be a determination by the court. I would be confident that the people would appeal again to this court if that court determined some sort of emerging adult standard, and the court would then have to rule on that record. So I do think procedurally, as far as Mr. Adriatico is concerned, there would remain a couple of additional steps even after resolution of the Guerrero and related issues.
May I ask about an issue that hasn't been discussed, and that was whether Mr. Adriatico should have had appointed counsel once his motion was filed. What's your view on post-conviction matters and the right to counsel?
So again, it would be absolutely within the purview of the Guam legislature to so provide. My understanding is it has not to date, and that this court has never previously required it. Under federal law, generally, there is no constitutional right, to an attorney in those post-conviction proceedings. I think the potential exception being where it's a form unlike this one, where direct challenge to ineffective assistance of counsel is available only through collateral relief. So, and I probably, that was a long way of saying that no, Mr. Adriatico did not have a right to counsel for purposes of the Superior Court proceedings.
But with the complexity of the issues and issues that are of first impression, don't you think that it would be sound exercise of discretion that Mr. Adriatico should be appointed counsel on remand?
If the court determines to remand the matter, then yes, and certainly yes. Not only as a practical matter, not only would it help develop the issues, but it would assist. It would likely assist the Superior Court in managing the matter. Having counsel helps. It can be difficult to manage a pro se matter, and so for those reasons, yes. But again, I would say that that's not a matter of constitutional rights or organic right. That would be for the convenience of the courts. I have almost overstayed my welcome if I haven't, but I would be happy to answer any other questions from the court.
We have no further questions. Thank you, Mr. Morris. You have 2 minutes, Mr. Hattori. Will you answer Justice Merriman's question about the appointment of counsel?
Actually,
And where would that right accrue from?
so that's what I would suggest, and that's what I wanted to address in my 2 minutes, is that so right now, if you get trial counsel and the trial counsel is ineffective, on appeal, you cannot necessarily raise it unless there's already been a record. And so your first chance to raise it will be in a writ of habeas corpus, raising ineffective assistance of counsel. So if you're not provided an attorney to raise it as on a petition for writ of habeas, you basically gone through the entire system without having counsel appointed to represent you. And so we believe that at least in a first instance to raise your writ of habeas corpus based on ineffective assistance of counsel, that you be provided an attorney. So like maybe it could happen either at the Supreme Court level when appellate counsel is appointed, they can also appoint a writ attorney, or it could happen, but we just can't allow the system to continue where you're unable to raise ineffective assistance of counsel claims at the appellate level, and then you're expected to file the writ by yourself behind bars without the assistance of counsel. And so as a director of public defenders, we know that it's going to be a burden that's going to fall on our shoulders, but we acknowledge that some of our clients, especially the ones that have these type of claims, should have counsel appointed to represent them to litigate it. Because it's not, I mean, if your claim is that you had an ineffective counsel, it's hard for a layperson to recognize that and also to make it. Because then maybe they didn't need a counsel to begin with, right? If you're able to effectively argue that. And so we believe that although it's discretionary in the rules, I think the court has the authority to just order it in the cases of first instance. It'll be like appeal as a right of, and the writ of habeas corpus has a right for the first time to raise that ineffective assistance of counsel issue. Thank you for your time.
Thank you, Mr. Hattori. Thank you, Mr. Morris. The court will take the matter under advisement and will now stand adjourned.
Rise.